everyone. My name is Heather Shoemaker. I'm an attorney with McDonald Hopkins. I'll let Kelly introduce herself too. You've got two of us on right now.
Yeah, good afternoon. My name is Kelly Campbell, and I am an attorney with McDonald Hopkins as well.
So today we're talking about legislative and regulatory updates. This year has been filled with data privacy acts and all sorts of other things. We are going to focus mainly on the notification requirements when you have a security incident. So the first thing that we want to talk about is state law. So I know all the sessions today have done a really good job of talking about, the cyber platform in the cyber world and what that looks like. And I'm sure most of y'all know when you have a security incident, there could be notification obligations that go along with that. Every state has their attorney generals have a data breach notification statute. And then there are specific regulatory statutes like New York Department of Financial Services. There's insurance statutes, and then there's also federal statutes that have these notification requirements too. And what we've seen in addition to the rise of the data privacy acts is there has been a rise in amending these notification statutes to make them more broad to trigger notifications maybe more quickly or for a broader set of information. So these are just some of the ones to keep in mind. So Texas, I know it's been about a year since this went into effect, but while you have 60 days to report to individuals of a breach of protected information, Texas amended its statute so that you need to report that 30 days to the Texas Attorney General if you meet the qualifications that trigger a reporting obligation. So you'll see a theme throughout these slides that a lot of these notification obligations are getting shorter. So one of the things that we talk about when we go through all of this, and one of the things that we would encourage you to take back to your companies is understanding who regulates you. And the state AGs are easy, right? Because that's going to encompass pretty much everything you do. But some of these more specified laws for understanding who regulates you, and then getting, somebody involved who does incident response pretty frequently that can help you keep track of when these obligations are triggered and how to report. So Florida, just a couple months ago, added biometric data and geolocation data to the statute of, defined personal information. The interesting thing is I don't think biometric data or geolocation data had a definition. So we are left to try to figure out exactly what that means. But I have a feeling that we're going to see that trend coming, especially as, Illinois enacted their biometric law, and we have a couple others that have been enacted recently to try to keep track of how people collect that data. But from a data notification standpoint, you now have to keep track of that for the state of Florida. Illinois, Kentucky, Maryland, Vermont, they have joined the ranks of the states that have notification obligations.
I just have water and I have
Sorry about that. They have joined the ranks of states that have enacted notification obligations above and beyond those to state attorney generals for insurance licensees in those states. Typically, those timeframes are pretty quick. They're usually 3 business days, I believe. And I think they can go as high as 30 days, but it's usually 3 business days from when you have a triggering event. So if you're trying to work through everything and trying to get back on track once you have a security incident, that's a pretty quick time frame. Indiana is one that is constantly amending their laws. Recently, they added a separate regulation for monitoring adult websites, which requires them to confirm somebody's age by asking for a date of birth. In conjunction with that, if an adult website asks for a date of birth to confirm somebody's age, that is now protected information under their state data breach notification statute, which could trigger a notification obligation to individuals and also the Indiana Attorney General. Additionally, there's a separate regulation that went into effect as of July 1st, where federal institutions that don't have a federal regulatory body and that don't have a deposit insurance provider, they now have to report to the Indiana Department of Insurance if they have a cyber incident or a notification incident. So these are just some of the variety of amendments that we're seeing that either added notification obligations where they didn't already exist or have expanded them to require additional considerations.
And, you know, to piggyback off of some of the states where we're seeing some, you know, stricter notification requirements and frankly, just more detailed, for, you know, requirements. Pennsylvania amended the data breach notification law that they had in place previously. The new amendments went into effect, or will go into effect rather, September 26th, so just the end of this month. And those amendments are essentially going towards the content of the notices and what actually triggers the notices to individuals. The first is that they expanded the definition of what personal information is, meaning the information that would trigger that notice, in addition to what was previously social security number, driver's license, financial account routing, account numbers. In addition to that, they've now expanded to medical information that's in the possession of state agencies or state agency contractors, health insurance information, users' names and emails with passwords. So either a username and a password or email address and a password that would permit access to an account. And that definition of medical information is pretty broad. So it's any individually identifiable information that would be contained in the individual's current or historical record of medical history or medical treatment or diagnosis created by a healthcare professional. So we typically see personally identifiable information or quote personal information defined by states, you know, nationwide as at a bare minimum social security number, driver's license, state ID, financial account information that would permit access to a financial account. But these additional identifiers are becoming more and more common. And so it's something to look out for. And in addition to that broader definition, Pennsylvania also explicitly now requires that 12 months of complimentary credit monitoring is offered in the event that a social security number or bank account number or driver's license or state ID number is involved in the impacted data. So that definitely is worth everyone's attention, frankly, especially in our industry where industry-wide 12 months of complimentary credit monitoring was certainly recommended, but in most states it's not required. While it might be industry standard if a social security number is involved. But now we're looking at the 12 months being required for individuals in Pennsylvania, even if there's no social security number involved. So that is something certainly worth keeping in mind. And as Heather was mentioning, some of the, you know, state AGs that we are required to notify and the timing for the other states, Pennsylvania also addresses that in this amendment. They are requiring that if there's 500 or more Pennsylvania residents, then they also would like you to notify their attorney general.
And just to piggyback off of what Kelly was saying real quick about the Pennsylvania amendments, it is very unique in this industry to see credit monitoring required for driver's license or bank account. Typically, that has been something that has not been readily offered since the credit monitoring really tracks your social security number. So this is a very interesting expansion. It'll be interesting to see if other states follow suit to try to expand those services. Because as of right now, as Kelly said, it's industry practice that you offer it for 12 months. Except in Massachusetts, Connecticut, and DC, which is 24 months, but really only for social security numbers that potentially could be impacted. So one of the other things that we're seeing right now too is the New York Department of Financial Services. If you are regulated by them, they have done some extensive amendments over the last couple of years, and they go into effect November of 2024. So in addition to breach notification obligations, they really require companies to implement some different infrastructures as well. So one of the requirements that they ask for now is to designate a chief information security officer, which I would assume that most of the businesses that are regulated by NYDFS, which is the abbreviation, have that already. But in addition, your CISO is required to create annual reports on cybersecurity programs and risks. So as part of your security program at your business, this is another thing that you're going to need to undertake if you're not already doing this. You also need to start implementing policies with certain encryption to protect non-public information. They used to allow a compensating control. So a compensating control, for those of you who may not know, is if you're not able to do exactly what is being asked, you can find a workaround, right, to do what you're trying to accomplish. For now, as of November 2024, you cannot use a compensating control for transmission of non-public information. It has to be transmitted in encryption. So just a couple nuances that if you're not tracking on it, you're going to have to start implementing some different things into your environment. Again, you have to maintain a business continuity plan. That's a little bit of a new one that they implemented as well. And then NYDFS still has a 72-hour reporting requirement. That was not amended. So once you determine that there's a triggering cyber event that requires notification, you have 72 hours to make that notification.
And before I jump into the next slide, I just wanted to recognize the chat. It looks like Eric Tolbert provided some additional detail, and this is not unusual. He's mentioning a specific Kansas law that requires similar timing of notice, 72 hours or 24 hours, depending on what kind of agency and how you are regulated by that law. But that's a great example of just being aware of, your local, regulators and exactly what requirements they outline. So moving into the FTC, so there was a couple of updates that are going into effect or have already gone into effect rather this year, this summer. So starting with the health breach notification rule, which became effective July 29th. So this law applies to vendors of personal health records and related entities, but that are not regulated by HIPAA, to notify consumers following a breach involving unsecured information. So the rule very closely tracks what we are seeing with what has already been in place for HIPAA regulated entities. And I'll provide some context to that as well. essentially the breach of security means unauthorized acquisition. So we're talking not just access, but evidence of unauthorized acquisition of an individual's personal record. And the requirements are to certainly notify that individual, the impacted individuals are required to receive notice within 60 days of discovery of the breach. This is also very similar to HIPAA's timeline. Notice is required to the FTC. If it's more than 500 individuals, then that notice must be provided within 60 days. If it's less than 500, then, if the notice is required of at least 500 individuals, the notice is required within 30 days. It's 60 days if you have less than 500. So the FTC is expecting to receive notice, and they have also included some additional color that currently is lacking from the HIPAA regulations, but similar to HIPAA, if you don't have contact information for, meaning addresses to provide the notifications, then for 10 or more individuals, you're going to be required to provide website notice for 90 days and media notice. Also similar to HIPAA, you'd be required to provide media notice if you have more than 500 individuals in one state or jurisdiction. And then the enforcement and civil penalties are going to be consistent with what the FTC has available as an unfair or deceptive act or practice. So that is certainly something to keep in mind, that we're just seeing a broadened, requirement, a federal requirement for this kind of information for individuals or for entities that are not typically or weren't previously required to provide that notice. And then in addition to that, we have another safeguards rule that's been in effect since May of 2024. It's requiring financial institutions that are not subject to the Gramm-Leach-Bliley Act to notify the FTC within 30 days of a breach impacting at least 500 individuals. And it's also requiring the written information security program that we do see other states like Massachusetts require. And some other states are developing, state-specific privacy requirements similar to this, but this is a federal regulation that's addressing it. And another thing to note is that this does impact and apply to auto dealerships. So that is one thing that some may not think of when they're thinking of financial institutions.
And schools, which is a fun one. Universities that offer financing. So, and just so you know, these aren't meant to be exhaustive, just a high level of what some of these look like. If we only have a half an hour, and if we tried to list out all of this, we would be here all day because there have been some substantial changes. The next one is the Security and Exchange Commission. So, this one, the amendments were adopted on May 15th, 2024. If you are a larger entity, you have an 18-month compliance period from the time they publish it in the Federal Register. If you are a smaller entity, you have 24 months from the time they publish it in the Federal Register. And there are definitions of what a larger entity and smaller entity are, so that you can figure out exactly which time frame you have to come into compliance. So one of the things that is in this regulation is that you have to send notice within 30 days of becoming aware of unauthorized access or use of customer information. So that is a pretty quick time period for anybody that's in this space. You know that sometimes it's hard to get your systems back online within 30 days. So it is a pretty quick time period. The sensitive customer information definition was expanded. So now there is a broader scope of information that you're looking for when you're going through that process to try to figure out which information was subject to this unauthorized access. So customer information was also expanded. And then once again, you can see here that the regulatory bodies have some consistency. They're now starting to require, incident response plans, business continuity plans, written information security plans. So in these data breach regulations and in these governing regulations regarding all of this data, they are starting to put in, additional plans and policies that you have to put in place. And like Kelly said, it's very similar in some regards to HIPAA with the privacy and security requirements that already required you to have all these policies in place. Now, for other types of businesses, their regulatory bodies are stepping in and looking to do that as well. So one of the things that the SEC notice requirement does have is they have a risk of harm provision too. So if you get to the end of your incident and you say, okay, well, I don't know, we sent it to an email address, but got a bounce back, or we learned that an employee took it, but the employee gave us all the data back, or whatever it is, you can do an assessment to determine that there's not likely to be used in a manner that would harm the consumer, and you can do a risk of harm to not have to provide notifications. There's other state data breach notification laws that already allow you to do that risk of harm analysis. HIPAA, if you're regulated by HIPAA, has that 4-part analysis that allows you to conduct a risk of harm with those 2 additional elements. If it was a ransomware, which we don't have time to get into because that's a whole nother conversation in and of itself, but you can see that everybody's kind of starting to follow suit, so that while the regulations vary and the timeframes vary, the underlying tone is the same. You have to have certain policies in place. You have to protect this data. You have to notify relatively quickly, and then you can, do a risk assessment and potentially, not have to provide notice.
All right, so moving into the Federal Housing Administration and this realm, we do have some regulations that address similarly tight timeframes for providing notice. So in this case, it's addressing simply just notice, though, to the Department of Housing and Urban Development within 12 hours of the detection of a significant cybersecurity incident. So this applies to Federal Housing Administration approved mortgagees. And the definition of a significant cyber incident is one that actually or potentially jeopardizes the confidentiality, integrity, or availability of information within a lender's systems, or affects the ability of the lender to meet obligations under applicable FHA program requirements. And so there are 2 email addresses that are provided, and those are going to be how you report the incident to both. It's the Department of Housing of Urban Development and their resource center. So they have a FHA resource center and a security operations center. And lenders must also report any effects on their information technology infrastructure and their response to the incident, as well as whether law enforcement has been notified. And just in this kind of world of housing and basically any individuals who, or in this case lenders, who are going to be potentially subject to this regulation, we thought it was also worth mentioning that Ginnie Mae has notice obligations as well. At the federal mortgage guarantor, Ginnie Mae requires a 48-hour deadline for issuers to notify of certain significant cyber incidents. So again, this is just something that, the more that you're aware of your organization, what role you provide, what kinds of services you're providing, it's really key to already understanding the timeline of the notice and frankly, what the notice is going to say, usually at 12 or 24 or 72, 48 hours. It's pretty tight as far as what you're going to be able to really report, depending on how complex the underlying incident is. But it's just really important to, to talk with legal counsel to make sure you're satisfying that requirement, but that you're also not providing information that you'll have to backslide on, or that you're not going to be able to confirm in, another 12 hours or in another 48 hours. So it's typically at this time a pretty high level notice, but it's something that we advise our clients on all the time.
So I'm sure everybody is well aware of the Cybersecurity and Infrastructure Security Agency, CISA. They have been making waves in the news for the last couple of years with the Cyber Incident Reporting for Critical Infrastructure Act that was put into place in 2022. They oversee that, and so they have been working diligently to figure out what those reporting requirements are going to be in its final form. So a couple things to know. The definition of a covered entity that is regulated by CISA and subject to CERCIA notification requirements is very broad. You may think, oh, well, I'm not a hospital, or I'm not, a water treatment facility, so therefore I'm not critical infrastructure. It is a very broad definition. Depending on how you read it, it could potentially swoop in pretty much every type of business, just by, how it is currently written. Reporting is within 72 hours if you are covered by CERCIA and you have an incident that qualifies under the definition. So you have to report to CISA within 72 hours. Right now, since it's not a final rule, it's voluntary reporting that you can do. And then if you make a ransom payment to the bad guys, you have to report that within 24 hours. So as you can see, once again, these tight turnaround deadlines. We expect that at some point in time, the final rule will be published in 2025, and then it'll go into effect with mandatory reporting beginning in 2026. As I said, right now it's still going through the phases, but this is what we anticipate to see from this rule. I don't know that the timeframes are going to change too much from where it is now into the final version. Any questions? I feel like that was a lot of information to get through in 30 minutes. And like I said, and like was pointed out in the chat, there's probably more laws that have been amended recently, because this is a very hot button issue for a lot of states right now, trying to figure out how to regulate the data that's being collected by businesses. So we would just encourage you to keep track of those regulators whom govern you, and just, make sure that you understand any amendments that have been put in place or any revisions to any of the rules, so that you know if something has been broadened or an additional requirement has been put in place. All right, well, thank you for your time. We hope you enjoy the rest of the rest of the meeting. Sorry, I lost track of my words there, but we hope you enjoy the rest of your time at the Stronger Conference. So thank you for joining us.